Hello, my name is Kevin Harrington, and I am the co-chair of the Trust and Estates section. Welcome to our program, Creditors, Claims, Do's, and Don'ts. Before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in your BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. Our next program will be on August 16th, and it will be discussing charitable donation of artwork to nonprofits. We also have a few words from our sponsors. I would like to start with introducing Brian Joy of the Sambor team.
Thank you, Kevin. We say this all the time, but we can't stress it enough how important working with a knowledgeable title company is. We are currently working on a new probate listing with a seller that has full authority. Before we even met with the client, which we're meeting tomorrow, we ordered a preliminary title report. In doing so, we learned that the title report reflects a covenant agreement for low-income housing from 1995, almost 30 years ago. The covenant states that the property must be sold to a low and moderate income person or persons. The city has to approve this, and they're supposed to receive a portion of the proceeds. When I mentioned this to the executor, he recalled that his parents paid off the loan with the city in a previous refinance. We are attacking this issue on two different fronts. First, the title company is calling the city of Los Angeles to ask for permission to remove this covenant. Second, the executor is looking through the decedent's paperwork to see that this loan was paid in full. Just like in your business, having a good team to rely on makes our lives much easier. Thank you for the privilege of your time and enjoy the meeting.
Thank you, Brian. We also have a few words from Orit Gadish of Geffen Real Estate.
Thanks, Kevin. For those of you who act as administrators or executors of an estate or as trustees, please check out my blog. I have 3 new interesting posts about how to handle difficult situations. My latest post discussed handling squatters, relocating occupants, and handling a property trash out and cleanup. The link to my blog is in the chat box. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate. We're a full-service firm. Not only do we help you with partial or full renovations, but we offer outside-the-box solutions for the difficult situations you may encounter when trying to sell real estate. I'm also an update author for CEB and the author of the Practitioner's Handbook for Probate Real Estate, which is available on Amazon. You can check out the 5-star reviews on Amazon. And if you're interested in a complimentary copy, text me now at 323-606-1919. Enjoy your program, and back to you, Kevin.
Thank you. In addition to the Sanborn team and Geffen Real Estate, the Trust and Estates section is also sponsored by Glen Oaks Escrow. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorships, and both court and independent administration of Estates Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. We're also sponsored by California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Lastly, we're sponsored by Manufacturers Bank. Simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estates banking team with the experience to handle all your banking needs. Contact Brian Flores, Vice President and Senior Relationship Manager for more information. Now I will turn our program over to Jacqueline Yu for our legal updates.
Thank you so much, Kevin. The first case for today's legal updates is Estate of Eskra, heard in the First Appellate District, Division 5. In April 2015, shortly before their wedding date, the petitioner Brandy Eskra learned that the decedent Scott Eskra wanted a premarital agreement. Each of them has a child from a prior relationship. Brandy and Scott each engaged independent counsel to enter into a premarital agreement. The agreement provided that the parties desire that all property owned by either of them be preserved as the separate property of each party. The agreement also expressly waived each party's spousal rights in the other party's separate property upon divorce or death. The day before Brandy and Scott married, they executed their premarital agreement. Scott died intestate in an accident in March 2018. After Scott's death, Brandy filed a petition seeking to be appointed the personal representative of Scott's estate. The trial court denied Brandy's petition based on the premarital agreement that waived Brandy's interests in Scott's estate. In a prior appeal, the court held that Brandy was entitled to introduce extrinsic evidence in support of her claim that their agreement should be rescinded on grounds that she and Scott mistakenly believed the agreement would apply only in the event of a divorce. On remand, Brandy testified that she instructed her attorney to remove the language in the agreement that waived each party's spousal rights in the other party's estate and overheard Scott instructing his attorney to do the same. Contrary to Brandy's testimony, however, Scott's attorney and other witnesses testified that Scott always wanted his estate to be distributed solely to his daughter and understood that the agreement applied in the event of divorce or death. The trial court found that Brandy's mistake was a unilateral mistake of fact because she alone was mistaken as to the content of the agreement, but that Brandy's mistake did not justify rescission because she failed to read the final agreement or consult with her attorney prior to signing. Brandy appealed, and the appellate court affirmed the trial court's decision, relying on California Supreme Court's holding in Donovan versus RRL Corporation. To obtain a rescission of an agreement based on a unilateral mistake of fact, the mistaken party must not bear the risk of the mistake. For our second case, it's the 2009 Metropolis Family Trust versus California Franchise Tax Board, heard in 4th Appellate District, Division 1. In this case, two non-grantor trusts, the 2009 Metropolis Family Trust and the Evan D. Metropolis 2009 Trust, were respectively 20% and 39.5% shareholders of PAPS Corporate Holdings, Inc., a Delaware S-Corp based in Connecticut with multi-state activities. In PAPS Holdings, Inc., it's a wholly owned subsidiary of PAPS Corporate Holdings, Inc. In November 2014, PAPS sold its interest in PAPS Holding, Inc. in a transaction that it treated for income tax purposes as a sale of the subsidiary's assets, including its goodwill. The primary issue in this case was whether the gain derived from the sale of goodwill should be sourced entirely outside California as income from intangible personal property pursuant to California Revenue and Taxation Code Section 17952, or apportioned to California as business income pursuant to California Code of Regulations Section 17951-4, subsection F. Section 17952 is a provision found under California's personal income tax provisions, which apply to individuals and trusts, and provides that income of non-residents from stocks, bonds, notes, or other intangible personal property is not income from California sources unless the property has acquired a business situs in California. On the other hand, Regulation Section 17951-4, subsection F, provides that in the case of a non-resident shareholder of an S-Corp that carries on a unitary business in California and elsewhere, total business income of an S-Corp is apportioned at the S-Corp level using the apportionment rules of the Uniform Division of Income for Tax Purposes Act, and the resulting apportioned amount is treated as California's source income to the non-resident shareholder. The trust asserted that pursuant to Section 17952, income from the sale of the subsidiary's intangible asset should be sourced to the trust's state of residence, which is outside of California. Neither of the trusts had a California resident fiduciary nor California resident non-contingent beneficiaries at any relevant time. The Franchise Tax Board issued proposed denials of the trust's request. The trust then appealed, and the Office of Tax Appeals issued a decision upholding the Franchise Tax Board's decision, which was upheld by the trial court and confirmed by the appellate court. Regulation Section 17951-4, subsection F, applied in this case because PAPS, an S-Corp, carried on a unitary business in California and elsewhere, and therefore its total business income is apportioned at the S-Corp level using the apportionment rules. The resulting apportioned amount would be treated as California source income to the two non-resident trusts who are S-Corp shareholders. Now I'll hand it over to Beth, our Assistant Program Co-Chair, to introduce our guest speakers.
Thank you, Jacqueline. Today we have the pleasure of hearing from Jerry Wyle and Jeryll Cohen about creditors' claims. Jeryll and Jerry are the co-chairs of the Trust and Estate Litigation Department at Freeman, and Smiley, where they are both partners. Jerry's practice focuses on complex litigation and dispute resolution related to trusts and estates, conservatorships, and guardianships, as well as appellate law. She is responsible for a number of significant California Supreme Court and Court of Appeal victories and has been the lead attorney in numerous multifaceted manners, which she has successfully concluded by trial, appeal, or settlement. Jerry was recognized by Best Lawyers as the 2017 Litigation Trusts and Estates Lawyer of the Year Award winner in Los Angeles. She has been selected by her peers for inclusion in Best Lawyers of America every year since 2010 and has been awarded an AV preeminent rating by Martindale-Hubbell Judicial Edition and is regularly named as the Southern California Super Lawyers list for over 10 years. She's also a two-time former chair of our esteemed section. Jeryll's practice focuses on complex trust and estates administration and estate planning, as well as dispute resolution related to trusts and estates, conservatorships, and guardianships. Jeryll has extensive experience in estate tax matters, from preparation of estate tax returns through defending the estate in audit, appeal, and litigation, and has particular expertise in issues arising from careers in the music and film industries, including the valuation and post-mortem administration and distribution of intellectual property rights. Jeryll has been selected by her peers for inclusion in Best Lawyers in America in the fields of trusts and estates litigation for 13 consecutive years. She has also been named a Southern California Super Lawyer list for 14 consecutive years and has been awarded an AV preeminent rating by Martindale-Hubbell Peer Review. In addition, she has been the co-author of Rudder Group Probate Practice Guide. With no further ado, I'd like to turn it over to Jerry and Jeryll. Unmute Jerry and Jeryll.
Thanks. Good afternoon, and thank you for joining us. This may seem to some of you, hopefully not too many, as a very dry subject. However, I actually find it fairly fascinating. It is very, very rule-driven, statute-driven. It is technically absolutely something that you must adhere to. And so every time a case comes into us with a creditor's claim issue, I go back to my codes and I review all of them in this area so that I have them in mind and have my deadlines all entered. And because I am very sensitive to deadlines, I'm going to start with a review of the deadlines. So you could turn to the first slide. And I'll also mention that Joy Morris, from our colleague from our office, helped us put this together and is going to do a brilliant job of running the slides for us this afternoon. Thank you, Joy.
Jerry and I are both past the age of when we would be able to do this ourselves.
So first, if you look at Probate Code Section 9100, and this is something that you, this is something almost to memorize, and we're going to talk about this later in the context of a case I took up to the, actually I didn't take it up to the Court of Appeal, but I argued at the Court of Appeal. Okay, so a creditor shall file a claim before expiration of the later of the following times: 4 months after the date letters are first issued to a general personal representative, or 60 days after the date the notice of administration is mailed or personally delivered to the creditor. Nothing in this paragraph extends the time provided in 366.2 of the Code of Civil Procedure. When another statute references the time for filing a claim, it refers to the 4 months, not the 60 days, as it says there. Nothing in this section shall be interpreted to extend or toll any other statute of limitations or to revive a claim that is barred by any statute of limitations. Okay, so if you could turn to next slide, please. Okay, so next slide. Code of, just as a refresher, Code of Civil Procedure Section 366.2 says if a person against whom an action may be brought on a liability, and remember that, it's a liability of the person, whether arising in contract, tort, or otherwise, and whether accrued or not accrued, which we'll also discuss, dies before the expiration of the applicable time of limitations period, and the cause of action survives, an action may be commenced within 1 year after the date of death, and the limitations period that would have been applicable does not apply. This limitations period shall not be told or extended for any reason except for sections 12, 12A, and 12B, which is how you count, not counting Saturdays, Sundays, and holidays, essentially. And then it talks about the creditor's claims as well. Okay, so now next slide. It is also Part A, which of Division 9 of the Probate Code, which is 19,000, which is the trust claims statutes, and then former Part 3 of Division 11 of the Probate Code regarding no contest clauses, which I don't think too many of those are still hanging around, although we do come across them, especially when we have estates where a surviving spouse has way outlived her predeceased spouse. And as you can see, the section applies to actions brought on liabilities of persons dying on or after January 1st, 1993. So that you will see specifically affects these no contest clause cases that are still hanging around. Code of Civil Procedure section 366.3 states that if a person has a claim that arises from a promise or agreement with a decedent to distribution from an estate or trust or under another instrument, whether the promise or agreement was made orally or in writing, an action to enforce the claim to distribution may be commenced within 1 year after the date of death, and limitations period that would have been applicable does not apply. The limitations period provided in this section for commencement of an action should not be told for or extended for any reason except, again, the counting of the days with the weekends and the holidays, and former Part 3, which was about the safe harbor petitions regarding the no contest clauses. That means that your filing a creditor's claim does not toll the statute as it does in other instances. So that is something to be wary of. Next slide. A claim barred by the statute of limitations may not be allowed by the personal representative or approved by the court or judge, and we'll discuss that later on in our program, but it is a warning. However, the tolling of the statute of limitations is a slightly different story under section 9352. The filing of a claim or a petition under section 9103 to file a claim, which is a late file claim, that's what 9103 is about, tolls the statute of limitations otherwise applicable to the claim until allowance, approval, or rejection. And you need to look at the code sections, and you need to calendar that outside date for the rejection and act accordingly. The allowance or approval of a claim in whole or in part further tolls the statute of limitations during the administration of the estate only as to that part that's allowed or approved. Next slide. 9353 talks about the effect of a personal representative rejecting a claim, regardless of whether the statute of limitations otherwise applicable to a claim will expire before or after the following times. A claim rejected in whole or in part is barred as to the part rejected unless the creditor commences an action on the claim or the matter is referred to a referee for arbitration. If the claim is due at the time the notice of rejection is given, it's now you have 90 days after the notice is given, and that has changed over the years. And by the way, you do need to consistently check when you have something like this with an up-to-date code, because these The codes are subject to change, and a minor change could be a major headache for you later on. If the claim's not due at the time the notice of rejection is given, and that's, I think you can look at the unaccrued claims 90 days after the claim becomes due. The time during which there is a vacancy in the office of the personal representative doesn't count against you if you are the creditor. Next slide. I pulled out definitions of accrued and accrue for everybody to look at, because that word becomes critically important in understanding 366.2 and the creditors claim statutes. So the Merriam-Webster dictionary just refers to it as something that is accumulating over time, a debt, or mainly a debt. But that's expanded under Black's Law Dictionary, where the accrue comes into it. It's whether a debt or cause of action comes into existence as an enforceable claim or right. And it also encompasses the accumulation that is noted in the ordinary non-legal lexicon. Next slide. Personal representative has an obligation to give notice. Next. Under 9001, there are two different, is the first way you give notice, and there are two ways. One, this is the publication of notice under section 8120 of the code, and giving of notice of administration of the estate of the decedent, and that constitutes a general notice to creditors who are creditors, and we'll discuss this in a moment, who are not known or reasonably ascertainable. And the public entities are exempted, and you'll see there's a whole slew of code sections regarding that, starting with section 9200. And just because the breadth of the material that we were looking at covering, we are not dealing with those public entity claims, and we'll refer you to the codes for that. Next slide. The other kind of notice that a personal representative has to give is personal notice. And that notice is to be given to the known or reasonably ascertainable creditors of the decedent, and that incorporates the Mulaney case, which we'll discuss in a moment. The notice shall be given as provided in the code, and you have to give the notice of administration. Look carefully at the language in that notice. Don't just fill in the blanks and send it out, because that is what you are telling your known or ascertainable, reasonably ascertainable creditors, and you give them a blank creditor's claim form. The notice shall be given within the later of, and here we go, 4 months after the date letters are first issued, and this is the later of it, either 4 months after the date letters are first issued, or 30 days after the personal representative first has knowledge of the creditor. The personal representative must serve notice to all creditors who are known or reasonably ascertainable. Due diligence is required, and Gerald's and my perspective is that the personal representative can never be liable for giving too much notice. It is the game of, I guess we could call it cat and mouse, with regard to claims, is a dangerous one for the personal representative, because it's possible that under certain limited circumstances, the personal representative could be personally liable for failing to give notice. It is not a risk that the estate bears as a whole. Next slide. By the way, notice is not required when the creditor has filed a claim or the creditor has demanded payment and the personal representative elects to treat the demand as a claim under section 9154. I said we would talk about the strict compliance with the technicalities of the statutes. And Tulsa, it was a US Supreme Court case, and Tulsa, the Supreme Court determined that mere publication is not enough for giving notice to the world, including your known and reasonably ascertainable creditors. You have to use reasonable diligence in finding those creditors. And that means telling your personal representative they really need to go through the papers of the decedent and whatever other sources of information they have with regard to the decedent's finances to determine who might be a creditor. Mullaney versus Central Hanover Bank and Trust limited the obligations of the personal representative. It is not, it's not a case where there has to be a wide-ranging investigation of potential creditors out there. Reasonable diligence does not require impracticable and extended searches. It's the reasonably ascertainable creditors, and again, that has been incorporated into our California statute. I'll also note that it's important for us to realize as we deal in an increasingly mobile and remote society that if one should not assume that all the states have the same rules and technicalities and deadlines. It changes on a state per state basis more than many other aspects of the probate practice. It can be 30 days, it can be 4 months, it can be a wide range of dates that are and deadlines that are given, and methods of notice and requirements for the personal representative and the creditors to meet. So beware. Okay, if you could move to slide 18. Nathanson versus Superior Court is a very interesting case. This was a case where the decedent's former wife filed a petition for a family allowance in the state proceedings. In her petition, which was filed within the period for filing a claim, a creditor's claim, she stated that she anticipated filing a creditor's claim seeking delinquent child support and life insurance proceeds due under a marital settlement agreement. She did not file the creditor's claim within the statutory period. After her petition for a family allowance was granted and the statutory period for filing a creditor's claim had expired, the decedent's former wife filed the creditor's claim along with a petition seeking to have the lateness of the claim filing excused. In the end, the California Supreme Court rejected her argument. The mere fact that the executor had notice of the underlying basis for her claim because the surviving spouse had mentioned these bases in her petition for a family allowance did not excuse her failure to present a timely claim. And clearly in the petition she filed, all of the facts that would have notified the executor were set forth, but that was not enough. The creditor's claim, a technical requirement, is indeed required. Under Venturi versus Taylor, the creditor's claim was filed after 4 months, waiving the formal defects does not include a late filed claim. The creditor was never given notice, and that was their argument, that they had not received notice, but the creditor, unfortunately for that creditor, unfortunately for the estate, had actual notice of the administration of the estate and was thereby bound. I will segue for a minute to talk about an interesting case that I had. I referenced it a little bit earlier. It is where let me give you the facts of this. The decedent died, and several days beyond the 4-month period within which the personal representative should have given notice to the creditors, the personal representative gave notice. The creditor, who was owed millions of dollars, filed and served the creditor's claim within the period that the 60 days would have encompassed. I think it was 41 days later, so it was filed just before the deadline would have run if the personal representative had served the notice on time. However, if we turn back to section 90, it's 90, 9050? 9051. The notice shall be given within the later of 4 months after the date letters are first issued, or 30 days after the personal representative has notice. Didn't make the personal representative did not make that deadline because they knew about it. So the appellate court, this is second district, it was an unpublished opinion, stated that section 9100A is unambiguous, and that was the claim filing statute. The time within which a creditor must file a claim is the later of 4 months after the letters are issued, or 60 days after the notice of administration is mailed. No language in the statute provides an opportunity for any other interpretation or limitation. And by the way, that statute was amended because originally it did refer, when it was first enacted, it did refer to 9051, which would have potentially barred the claim. But because the statute has been amended and before the death of this decedent, the new statutory language did apply. So let's see. There's another part of this case which we're getting to, and that is the technical requirements of the claim as filed. That's slide 19. And look at these code sections carefully. The creditor gets the creditor's claim judicial counsel form, which needs to be filled out. And there needs to be an affidavit signed under penalty of perjury with documentary support. Any written instrument needs to be made available. If you don't provide the original to the personal representative, they're entitled to see it. And this same case where the timeliness of the filed creditor's claim was litigated, there was also an issue as to the affidavit with the documentary support. There was, the creditor's claim was, it's in and of itself described the debt and was signed and presented, served and filed with the court. The supporting documentation, which was, I think, 232 pages long, was provided to the personal representative both before the creditor's claim was filed and along with the creditor's claim in a binder. The language in the code says that it's to be attached, and this clearly, as it was in a separate binder, was not attached. It also was not at that time filed with the court, the documentary support. And the final determination, both at the trial court level, at the probate court, and that was Judge Klein, and at the appellate court level, was that the supporting documentation did not need to be attached. The personal representative was on notice, had all the information available. He stated that he didn't need any more information and would request it if he needed it. He believed the claim was valid. He did file that in a petition to determine the validity of the claim, stating that he believed it was with the court, and it was the burden of the beneficiary to prove that the claim was not valid, which was definitely a decision made by the personal representative to handle the claim that way. In the end, the court did uphold the Judge Klein's ruling, even though the documentary support was supplied afterward. The court stated that there was no amendment to the claim. The supporting documentation was voluminous, and the personal representative again had said it was sufficient. Moving on, Probate Code Section 9000. What is a claim? And a claim means a demand for payment, and that's different than under 366.2, which is a liability. And I point that out because this is a demand for a money payment. And that is what the creditor's claims statutes are aimed at, whether accrued, again, that word, accrued or not accrued, or contingent, and whether liquidated or unliquidated. It is a liability of the decedent, whether arising in contract, tort, or otherwise, liability for taxes, whether assessed before or after the death, unless it's secured, and the liability, and one exception for post-death expenses of the funeral expenses. A claim does not include a dispute regarding title of a decedent to specific property alleged to be included in the decedent's estate. And that's under Probate Code Section 850. And a creditor means a person who may have a claim against estate property. Next slide. I'm turning it over to Jeryll.
So now we have the basics about what is a claim and what you have to do if you have a claim. And there are a whole series of cases addressing whether you have to file a creditor's claim in a particular kind of action or claim, and whether you don't. So I'm going to go through examples first, examples of cases where the courts found that no creditor claim was required. Slide number 22, please. Oh, that's there. Patrick versus Alistair Corporation was an action where the surviving spouse was seeking to confirm her ownership of her community property interest in assets in the estate. And as she was seeking specific property and a determination of ownership of property, that was not a claim of a creditor. She was not a creditor of the estate because she owned the property. Embry versus Embry also it is distinguishable because that involved a claim for a support judgment, which is not a claim for specific property, but that's a claim for to collect a money judgment. The general principle really that applies with Alistair is that when you are seeking specific property, you are not a creditor of the estate because you're not seeking assets that belong to the estate, you're seeking assets that belong to you. In Ray Dabney's estate also involved a claim to specific property, as did Alvarez versus Ritter, which involved the reformation of lease and a return of rents that had been paid. So even though the claimant was seeking to have the return of money, the court held that the money that the claimant was seeking didn't belong to the estate because it was due to the owner of the property, and the estate didn't own that percentage of the property. In Arguella Estate Protective Association versus Crofton, a similar case, the decedent had assigned a half interest in particular property and a half interest in the rents to another person. And when that person sought to collect the rents, the court held that person was not a creditor of the estate and did not need to file a creditor's claim. Now, what's important is that the court pointed out that this is a different situation than if the claimant had been seeking an action on conversion, because then they would have been seeking not a specific fund or specific property, they would have been seeking money from the general funds of the estate. And then they would have had to have filed a creditor's claim. In Dunlap versus Commercial National Bank of Los Angeles, the court held that where the claimant was seeking to collect funds represented by a check that had not been cashed before the decedent died, that was a claim to the specific funds that were represented by the check. Because once the decedent signed the check, the money described in the check no longer belonged to the decedent and didn't belong to the estate at the time of his death. And therefore, the claimant did not need to file a creditor's claim. In Anderson versus Broadwell, also a similar case, the claimant was seeking to collect royalties on property that the claimant owned. They did not have to file a creditor's claim in order to pursue that action. These types of actions are brought under Section 850. And there was a time when it was held that the probate court did not have jurisdiction to hear adverse claims to property. That changed when Probate Code Section 850 was enacted. And these cases are still applicable because we have Section 850, which allows you to seek a specific property from or determination of ownership of specific property. And the creditor's claim statute itself says that the creditor's claim filing rules do not apply to a claim for specific to title of property. A claim for contribution for payment of the estate's share of liability, where the estate and the third party were jointly obligated on a promissory note, and the joint obligor paid the estate's share after the decedent died, did not need to file a creditor's claim. First of all, the mortgage was not in default at the time of the decedent's death, and the court held that the right of contribution arose after the decedent's death and involved a separate agreement, not the agreement that established the liability, not the promissory note, but an agreement between the joint obligor who voluntarily paid the decedent's share or the estate's share actually at the time of the obligation. Interestingly enough, I wonder if a claim for indemnification where there's a contractual right to indemnification would be treated the same way, even if the right to indemnification or the action that gave rise to the indemnification doesn't occur until after the decedent's death. If I represented a client that had a contractual right to indemnification, I would recommend filing a creditor's claim, even if the right to the indemnification had not occurred prior to the decedent's death, because I think that because it's a claim on a contract, that would still require the filing of a creditor's claim. An action for rescission of a contract and recovery of the purchase price was held not to require the filing of a creditor's claim in Payless Drugstore versus Beckdolt, which is a 1979 case. Interestingly, there was a case in 1936 where the court held completely to the contrary, and that's Jacobson versus Meade. Jacobson versus Meade was a second district court case, which is our district, and Payless is a third district court case. So I'm not sure what the state of the law would be if this ever came up. The court in Payless said about the court's decision in Jacobson versus Meade, because of the unique and egregious facts of that case, the lack of complete unanimity of that court, and the absence of a reasoned analysis of Section 707's applicability, we do not deem it valid authority to support the trial court's decision. So the court in Payless simply disregarded the prior court's decision on the same issue in Jacobson. An action seeking to compel the executor to pay an encumbrance that the decedent had agreed to pay when he transferred title was also held not to require the filing of a creditor's claim. This was an action that was brought under Section 850, and the court held that the decedent had transferred title to the property and had promised to transfer title clear of any encumbrances or liens. And the money that was due to pay the encumbrance was not due to the plaintiff. It was due to a third party, and therefore the plaintiff did not have to file a creditor's claim. In Sperry versus Tammany, the husband and wife owned property, and after the wife's death, the husband paid the wife's share or her estate's share of a mortgage. The court held that his seeking reimbursement from the estate or a credit for the amount of the estate's share of the mortgage that he paid did not require the filing of a creditor's claim, as the husband was not a creditor of the decedent because he made the payments after her death. In Wright versus Superior Court, by the way, the citation for Wright versus Superior Court has a typo. It is 85 Cal App Second, not 84 Cal App Second. Wright versus Superior Court of the City and County of San Francisco was an action for specific performance. It was not an action to recover a money judgment. And that was the distinction the court made in that case as to why the plaintiff did not need to file a creditor's claim first in order to pursue the action. Erickson versus Booth involved the right to renew a lease. And again, because the claimant was not seeking a money judgment, but was seeking, in essence, specific performance, no creditor's claim was required. In Estate of Bonsi, that was an interesting case that involved an order requiring, an old order requiring that funds be used to remediate particular property. And after the death of, there were a number of different owners involved. It was a very complicated case, but the Regional Water Quality Control Board and the Department of Resources Recycling brought an action to enforce that judgment requiring remediation against the estate. They did not file a creditor's claim first. And the court held that because the plaintiffs were not seeking money for themselves, but rather were seeking to enforce a judgment that required the payment of money to remediate the property, they did not have to file a creditor's claim first. And I think Jerry's going to go over cases where the filing of a creditor claim was required.
So the three cases I'm going to discuss in this section are all pretty old. They all predate the shift that took place where the probate court had expanded jurisdiction and also the overhaul of the entire probate code. So, but I still think that these principles apply nonetheless. In Hayes versus Bank of America, the creditor or claimant claimed wages for services under a contract to cut timber. They did not file a creditor's claim. The complaint was filed instead under the Federal Fair Labor Standards Act in existence then. The holding was that the claims were based upon contracts, or at least incident to contracts, and as no creditor's claim was filed, the action was barred. The sustaining of the demur at the trial court level without leave to amend was upheld. Pelser versus Pelser was a dissolution action, and that's from 1960. The final decree included a judgment for child and spousal support continuing until the wife died or remarried, and also child support that continued. The husband died, and the wife, who was surviving and had not remarried, moved to substitute in the administratrix of the decedent into the divorce action. And the motion was granted, and the claim was for money in arrears, as well as future payments. The holding, and again, no creditor's claim was filed. There was a holding was a final divorce decree is a judgment, and while the court retains jurisdiction for continuing payments of support, that's the family court, that is not on a basis to ignore the creditor's claim filing requirements for a judgment. So the order substituting the administratrix was reversed. In Lesser versus Poman, that was a claim for future rent. The decedent leased property for a 5-year term and died during that term. The special administrators occupied the premises for a period of time, and the lease contained language that bound heirs, executors, administrators, successors, and assigns. The plaintiff, the lessor, sought to enforce the lease and used 2 different complaints to do so. One was a money judgment, and one was a declaratory relief complaint. The holding, again, was that a creditor's claim, which was not filed, had been required. Where the decedent's estate is liable for a debt, the creditor's claim must be filed. There is no recourse against a surviving spouse's community property, as no creditor's claim was filed, and the language binding the heirs, executors, etc., was ineffective where the heirs, executors, etc., did not separately covenant to pay. I think now we are Jeryll.
So there are a number of statutory exceptions as well when a creditor's claim is not required to be filed. Probate Code Section 9390, which involves claims where there is insurance coverage. If there is insurance coverage and the plaintiff is seeking only the insurance funds and nothing in excess of the insurance, they do not need to file a creditor's claim first. Real property liens, a creditor's claim is not required. And then, of course, Probate Code Section 9000B, as we've already discussed, a claim for specific property, a creditor's claim is not required. Claims by public entities are subject to a different set of rules. Each public entity has its own statutory requirement, and so you would need to look at each specific entity to determine what is required. The US government's not subject to any of these probate code claim filing requirements. They have their own rules. So you need to look at each specific code section dealing with a specific public entity. It's very important to be very conscientious about reading carefully all 3 of the statute of limitations statutes that we mentioned to you. The probate code claim filing statutes, CCP section 366.2 and CCP section 366.3, because they are not identical and they don't all cover the same kinds of claims. So you might have a situation where you've satisfied your probate code claim filing requirement, but you blew the 1-year statute of limitations under CCP 366.3. Now, 366.2, as we mentioned earlier, does include a provision saying that the filing of a claim tolls the statute of limitations. 366.3, which involves a promise to make a distribution from a trust or a will or an estate, does not include that same provision. So you might file a claim and then not file your lawsuit within the 1-year period, and then you're in trouble. And in fact, there are a couple cases where that very situation occurred. And that's, I think, Stoddard versus Allen, which we have they are later on in the slides. 366.2 is the 1-year statute of limitations that says you have to bring a lawsuit within 1 year of the decedent's death. Now, the definition of what triggers the running of 366.2 is not the same as what triggers the requirement that you file a creditor's claim. Again, there are overlaps between these statutes and there are also gaps. In a state of Ewell, the action there involved the daughter brought an action to recover property that was in her mother's name. Her mother had died, and she claimed that the property actually belonged to her, that her mother had taken title simply in her own name. And in that case, the court said that this was not an action on a liability of the mother. This was an action to determine ownership of property, and 366.2 did not apply. In Sefton, that case involved a situation where a grandson was seeking to challenge the exercise of his grandfather's power of appointment, and the court held that 366.2 did not apply because the grandson was not seeking to recover on a liability of his grandfather. Dacey versus Teraday is a great case for explaining the interplay of these statutes. And in Dacey, the court pointed out that the difference between 366.2 and the creditor's claim filing period is that in 366.2, there must be a liability of the decedent that exists upon which the claimant can sue on at the time of the decedent's death. That's when 366.2 applies. And in Dacey versus Teraday, the court held that that did not exist, that the case involved an agreement for the recovery of fees between partners in a law firm. And the case was pending, which resulted in the fees for the law firm at the time of the decedent's death. It was one of the law firm partners. And the court held that the plaintiff seeking the recovery of the fees was not required to file that lawsuit within 1 year because the cause of action did not exist until the case, which resulted in the fee award, finished. And that happened after the decedent died. Now, interestingly enough, the court did not address the issue of whether or not a creditor's claim should have been filed by the claimant because the court held that the estate did not preserve the right to raise that claim. I think that they had raised it in a footnote, and this is a lesson learned. And the Court of Appeal held that raising an issue in a footnote is not sufficient to preserve it on appeal. So in order for 366.2 to apply, there has to be a cause of action that exists at the time of the decedent's death. And the court in Dacey versus Teraday dealt with the potential public policy problem that would arise as a result of these two different principles. And what the court said is, if you have a claim based on a contract, even though the right to the recovery doesn't exist yet and you can't sue on it, because it is a claim based on a contract, you need to file a creditor's claim within the probate code creditor's claim filing period. So that's very interesting. In Ye versus Lee Cheng Tay, the court held that the statute of limitations under Family Code 1101 on a spouse's action for breach of fiduciary duty trumps CCP 366.2, and 366.2 did not apply. And so the spouse's claim under 1101 for breach of fiduciary duty, which the spouse brought after 1 year after the decedent's death, was allowed to continue. 366.3, as I mentioned, is about claims to recover on a promise to leave property, to make a will, to make a distribution from a trust. And again, there is no tolling of the statute of limitations under that section for the filing of a creditor's claim. In Jolly versus Martin, that was interesting. That was a claim for reimbursement of Medi-Cal payments from a trust. And the estate tried to argue that the government was actually seeking reimbursement on a promise to repay the government. And so therefore their claim was barred by 366.3. And the court said, no, the government is seeking a claim based on a statute, not on a promise to make a distribution from a trust or to leave money under a will. And I think we are getting close to the end, so I will let, we can address waiver and estoppel, which are, which you might want to try to argue if you've blown these statute of limitations. What do you do then?
Okay, so looking at Varney, which is a relatively recent case, and there are not a lot of creditors' claim activity at the appellate court level that's published. That's 1992, and that stands for the proposition that the appellate court can toll the period for filing a creditor's claim pending resolution of in this case, it was a writ proceeding, because the creditor sought review of an adverse probate court ruling before the time for filing the creditor's claim had expired. And that must have been a very stressful 4 months for the creditor. Everything was very tightly timed, but he did pull it off. And the Court of Appeals said, although the personal representative and the probate court can't waive the requirement of the 4 months after letters, the appellate court can. And then Jeryll, you want to do estoppel?
So equitable principles still apply. And when all else fails, you can try to, a sad creditor who has failed to file a lawsuit within the 1 year or file a creditor's claim within the 4 month period, may be able to argue that the estate is stopped from asserting the statute of limitations bar. Estate of Prindle actually was interesting. In Estate of Prindle, there was a claim made against the plaintiff. There was a claim made and it was covered by insurance, but the insurance company refused to defend the estate. And so the action proceeded against the estate, and the estate lost, and the insurance and brought a bad faith action against the insurance company. The insurance company then tries to raise the defense of failure to file a creditor's claim. And the court said it wasn't raised in the trial court. And even though you weren't a party, too bad, you can't raise it now. You are stopped to raise that defense against the estate. And then, of course, there are situations where the claimant has been induced by the personal representative not to file a creditor's claim, either because there was a settlement reached which I think is Satterfield versus Garmier, or where the personal representative says, don't worry, you don't have to file a claim. We're acknowledging your claim, all is good. However, I would not want to be in the situation of trying to argue estoppel. I would much prefer to have filed the claim within the periods required. I think you're in a much better position to have done that than be relying upon the equitable arguments after the fact. And then there is a statutory provision that allows for the filing of a late claim under very, very limited conditions, and that is Probate Code Section 9103. And I urge you to read that section very carefully because it is very limited as to when the court will allow you to use that statute. And it still has to be brought within 1 year after the decedent died. One of the things that we did not talk about, which I just want to mention, on 366.2, the filing of the creditor's claim tolls the statute of limitations, even if no personal representative has yet been appointed. So if you are running up against that 1 year deadline, you open up a probate estate, just petition to have a special appointed and file a creditor's claim within the 1 year period, you will have satisfied the 366.2 statute of limitations requirement.
And I'll just mention that Jeryll and I have been doing this cumulatively for a lot of years. But when we're faced with creditors' claims matters, we go back to the books, we go back to the code, and we read it and we read it, because it is, as today's presentation has hopefully shown, a sticky wicket. You got to really cleave to it. And with that, I don't know if we have time for any questions.
Thank you both for that very informative presentation and for materials that I know and I think many people will be looking back to as a great resource anytime these issues come up, in addition to the code itself. I was going to give you just maybe 2 questions quickly, if you don't mind.
Okay.
The first was, if a complaint for a breach of contract was filed and served prior to the decedent's death, but pending at the time of death, is a creditor claim required?
Yes, a creditor claim is required. For sure, if a probate has been opened. If I were representing the plaintiff, I would start a probate and get a creditor's claim filed. And then there's a process for having the estate substituted in as the defendant. There's a specific statutory process for doing that.
And then the second one I'll give you is for the requirement that notice be given within 4 months from letters being first issued, would this period run from when special letters are issued or only once permanent letters are issued?
It's from when a general personal representative is appointed, being a personal representative with general powers.
And that can be a temporary letters if they give general powers.
Perfect. Thank you both again. I mean, really for an excellent presentation. We really appreciate your time today. And thank you everyone for attending. We hope to see you next month.
Our pleasure. Thank you.
Thank you.